I'm Launi with Learn Law for All, and today we have Angie Hallier with us. Angie, welcome.
Hi, Launi. Good to see you.
Thanks for being here. So a little bit about Angie is that she's really inspired to help clients not only navigate the process of divorce, but to envision a plan for a positive future. And I love this about Angie. She is like a whole picture person, which I love from the beginning, from the time she meets the client until the divorce is done. And so she's really got some great information. Today, we're actually talking about cross-examinations, and we just did a CLE on this. It was amazing. And so I encourage you to watch that on our Learn Law for All website. As a just reminder, our disclaimer, watching or listening to this video does not create an attorney-client relationship with me or with Angie. The podcast is for educational purposes only and not created to give anyone specific advice about their case. Angie and I are both only licensed in Arizona. However, the information provided is general and likely applicable to most, if not all, jurisdictions. So welcome, Angie.
Good to be here.
So it was a great CLE. I appreciate you doing that. We really talked about cross-examinations with lay people and with your own client and prepping them. So can you kind of tell us what the purpose of cross-examination is?
Yes. And as I said in our educational part, I love cross-examination because it really is your chance to wow the judge or the jury with how wrong the other side is. But it takes a lot of preparation. But just generally, you want to expose the weaknesses in the other side's case and redefine what was heard by the judge or jury on direct. So on direct, the nice story the other side had will be presented. But as we all know, there were probably gaps and holes that you can point out on cross-examination. So you want to redefine in the judge or jury's mind what they heard on direct and add those missing perspectives. Because, when you hear part of a story, you don't hear the whole story, then you don't know the whole truth. So you want to fill in those gaps that are meaningful for the judge or jury. And of course, you want to impeach the witness themselves, their memory, their credibility. You want the judge and the jury to think they're lying, or they don't have a good memory, or they can't be trusted. And in that way, potentially make that witness unlikable to the judge or jury because, personal biases affect what we think. And if you can show someone to be a scoundrel or a liar or just not having a good memory, you can get the judge or jury to form an opinion about that person that can help with the outcome. And then lastly, you want to show the judge and jury that you, the attorney for the person in the right, knows the facts better than the other side, knows the data points better than the other side. And I think cross is a great way to do that because I think many attorneys fall down on the job in really preparing that dramatic, amazing, wonderful cross where they have every data point at their fingertip if the witness won't admit to something. And that gives you and your client credibility.
Angie, that's one of the things I love about how you practice, because again, like I said, you're a whole picture kind of person, and you do this from the very beginning. I've been in, intake meetings with you when we were doing an intake with a client, and you really start the picture from the very beginning. What is this case about? What does it look like? And then you sort of wrap it up with the cross with duh, I was right, kind of, you know what I mean? Like right. That's kind of, it's kind of like I said this and this and this for this whole time. And then, exclamation point, I was right, is kind of how I think you use your cross, which is amazing.
Well, yeah, it's to tell that story, right? Because every case has a story that needs to be presented, and you want to prove that your story is the correct one during the cross. And by the time you get to trial, I'm kind of mad by the time I have to go to trial that the other side wasn't reasonable enough to settle. Now, I know that's not universally true, but often I feel like, look, I feel like I've been doing this long enough. I have a pretty good sense the parameters within which this thing is going to go down. And I've told my client that. And if you've got me to the point that I actually have to go to trial to prove my point, then I'm a little ticked off on you, and that might come across in my cross-examination.
So let's talk about that. How do you lead your witness down the path of sort of to get to your end, to get to the end result that you want?
Right. So, I mean, it's kind of a 3 points to make that I think about when I'm doing this. So I always, for each topic or each point I want to make with the witness, I first get them to admit what they've testified to or what they've asserted is the truth or what, they've said in their deposition. And, it's always yes or no answers, always. Isn't it true that, didn't you do blah, blah, blah? So isn't it true that you said in your affidavit to the court, you only make $5,000 a month? So you start with that truth, get them to reiterate what they said. Then you present, point 2 is present the witness with contrary evidence. Okay, so that's what you said, but let me show you this car application dated last month when you bought your new car. What does it say? Doesn't it say on line 17 that you make $15,000 a month from your business? They have to admit it. It's there because when you're doing cross, you've got to have documents to prove all your points. Or you say, and oh, by the way, here's your bank account statements. Don't they show a total of $200,000 deposited over the last 12 months? But you still say you make $5,000 a month, right? And then point 3 is you force the witness to admit that they were wrong or they lied. So when you told the court in your affidavit you only made $5,000 a month, you were lying. No, I wasn't lying. Well, that's fine too. If they say yes, they were lying, great. If they say they weren't lying, it's fine too, because the documents show that then either they lied when they bought the car, which isn't good either. It hurt their credibility. Or that somehow they have sources of income they haven't disclosed in their bank accounts. So again, it's start with the truth or something they've alleged, get them to reiterate that this is their position, present them with contrary evidence, and then force an admission at the end. And like I said, if they refuse to admit the truth at the end of that, they still look ridiculous because it's obvious to everyone else listening that they were lying or weren't correct about their first thing.
Yeah, that's a great point. I love how you wrap that up and bring it back in, because I think it's so important. And look, the judges have so much discretion, right? So when you make a judge not believe somebody, all of a sudden you get to see a minute entry that says, well, we don't believe, so-and-so's testimony was credible.
Right.
If you can get that, then your client holds on to that forever, because then you continue to show that to all the other judges, that come up in the case later.
Well, and to your point, if you can show a witness you're doing cross on does not have credibility in one area, people just infer they might not have had credibility in other areas, even things you might not have proof about. So it just helps overall.
Right. So one of the other things that we talked about, and I know we spent like 3 slides on it in our CLE, but we talked about preparing your own client for deposition. So what are kind of your big tips for preparing your client? Maybe a top 5 tips.
Right. So I feel like the best thing you can do for your client is get them in and out of cross, right? Don't just make them a little bit pliable, saying yes or no, I don't know, I can't answer the question. Number 1 rule, do not argue with the person asking you questions. Don't try to tell your side of the story to the person asking questions. Now, don't listen to the question carefully, because we've both had clients that didn't listen carefully and made admissions that they shouldn't have. But listen to the question carefully. And even if it sounds bad to admit something or deny something, just do it if it's the truth, because I can come back on redirect and help you. So I think that's really the most important. It's just human nature. The person is already mad at the attorney on the other side because they're in trial and they're being cross-examined, and they just want to either argue or tell their story. So practice with them. Yes, no, yes, no, yes, no. I don't know. I can't answer it that way. And talk to them about the redirect. Also make sure they're familiar with all the documents that might be used on the cross, all those little points where they didn't say the right thing, or they made a mistake, or they said something in their deposition that turned out not to be true, and practice with them doing that so that they're prepared. And then I like to work on the tone of their voice as well, because usually cross-examiners are a little dramatic and loud and accusatory. And so if your client can stay calm during their cross-examination and just kind of, yes, no, keep a smile on your face, use a lower tone of voice, don't match the volume and the dramatics of the other person, kind of takes the punch out of the cross.
Okay, I know we didn't talk about this before, but it just came to my mind. What do you tell your client if they say, I'm not going to look at him. I'm not going to look at that opposing counsel. He's a jerk. I hate him. I can't look at him. And I know we've all had that client, right? Like they just hate the opposing counsel so much as if it's the opposing counsel. And sometimes it is the opposing counsel. I mean, in all fairness, that's being a jerk. But what do you tell your clients?
Yeah, I tell them they have to look at him, or look at the judge, or look at the jury if there's a jury. I mean, you can't just, this is an act, right? Because I'm teaching you to put on an act so that you do the best you can, because I know you want to rip their eyes out. I know you want to jump up and down and scream and say this isn't fair. But if you want the least sting to attach to you because of your cross-examination, you have to be cordial and calm and nice and not flustered by anything they ask, knowing that I will be able to come back and have you explain it. So I don't know,
that's great. Yeah, I do the same thing, because you don't want them. This is a fake it till you make it kind of thing, right? It does suck. This might be terrible, but just sort of suck it up to get you through that point. If you have to look up here as opposed to the eyes, no one's probably going to notice. But yeah, you don't get to go and look pissed off, right? I mean, right. So that's one thing. Okay, and so I know another thing that we didn't talk about, but I do want to just ask you to repeat the story because I love it so much. Is the story that when you, oh gosh, what was I thinking now?
Oh, I don't know. When I did my hand movement.
Yes. Well, yeah, that one. The when you, because this is great for this is great also for your clients. When your clients just act like they're answering yes, of course, then it's as if they're right, but kind of the same thing you did with the expert. So can you share that story?
So I was sharing a story where I was cross-examining an expert, and this expert, financial expert, refused to say yes or no. And, judges they're a little more lenient, I think, with experts than with parties on saying yes or no. So I asked something that was a yes or no. Isn't it true that blah, 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 blah. And then he gave this explanation. And I didn't know what he was saying. And I'm looking at the judge, and she doesn't understand what he was saying. He was explaining something very technical about his calculations. And so I just took my hand and slammed it down and said, exactly. And I have to say that expert and I have laughed about that for years, because the judge thought I'd made my point. And I don't even know if I did, because he was, the way he was talking was like, it wasn't anything in his report. He was going off on something totally else. I didn't know what he was saying. So, sometimes you can just make lemonade out of, what do you make? Lemonade out of lemons?
Lemonade out of, yeah, that was so great. All right. Well, thank you so much for sharing that. All of Angie's contact information will be in the description. And along with you wrote a book. By the way, I think it was a 10-year anniversary just came up on the release of it.
Oh, great. Yeah. I guess I need to do an update.
Yeah, it was on my Facebook as a memory when we went to your signing party. So
thank you.
So happy 10-year anniversary.
Thank you so much.
So that'll be linked on it. It's a timeless book. So it's not going to it's not missing anything. It's very timeless. It's great advice. That link will be attached to this podcast and to the CLE. So
thank you.
Thank you so much, Angie. I appreciate you so much.
Okay, thank you.